We finally have our first hearing in the FSU ACC lawsuits. Do we have a dismissal?
The ACC lawsuits are always in the news, so we're back on the big mountain to keep you updated.
Hey, it's good to have you here again on the mountain. I am JY. This is my good friend Steve. Steve, we're doing what we would consider a breaking episode. We don't do this very often, but we both had time today. We get together. We want to talk about the hearing in Mecklenburg, North Carolina. Finally have our first hearing on this ACC FSU craziness that's been ongoing. So this hearing was on the motion to dismiss or stay, and also on the motion to seal from ESPN. So again, this was in North Carolina. So the dismissal request was from FSU here. Judge Bledsoe is presiding, and I also heard Judge Bledsoe has been given the case for Clemson as well. So, and I think we might bring that up here in a little bit.
Yes.
There was apparently one news outlet that was allowed in the courtroom, WSCO from Charlotte. I'm anxiously awaiting to hopefully get video of this. It wasn't live streamed or anything like that, but there is apparently some video. The information that I'm going to be going over is from Rohan Law. Got them off of X, and he went through, kind of just was texting out things as they happened. I wanted to pull out some things that stood out to me for the most part. And again, I didn't hear it. This is coming secondhand from what he was putting out there. But again, really important case, and wanted to do an episode on this. It was about a 3.5 hour hearing, for crying out loud. Very long hearing. So they started with Mr. King, and he represented FSU. And the two really main things that they really talked about in the motion to dismiss, it always seemed to come back to both the standing question and then also the sovereign immunity question. So those are going to be the main 2 points that I'm going to be talking about. But obviously King talked that ACC did not get approval. We've said this many times. Everybody knows this, but they did not get approval to file their suit in December. And there was a lot of back and forth with the judge there. The judge then said the ACC determined that this was not a material litigation. That's what the ACC has been putting forth. The judge kind of repeated that. And he then said the conclusion for this, and the only way to upset that is if the court finds that was unreasonable. That was a reasonable conclusion by them, or if it perpetuated a fraud. So the judge has to determine, okay, was this or was this not material? We'll get into that here in a little bit. They then got into some sovereign immunity types of discussions. King suggests that FSU is different than that Farmer versus Troy case that was brought up because FSU did not and has not registered in North Carolina, nor have they gotten a certificate of authority in North Carolina. That is what makes this situation different from that case that the ACC has put forth. Also stated that the ACC is subject to the state statute. The members are not subject to the state statute. The judge pushed back on this a little bit and stated that if FSU waives sovereign immunity in Florida, he can apply Florida law in this North Carolina case. I'm not sure if everybody would agree with that or not, but that was kind of where he was coming from. Cooney then got up, so about an hour with King. Cooney then got up for about an hour. He represents the ACC. He went right into standing. The judge says that everyone agrees that a vote is required to be taken per the Constitution for a material litigation. And again, it's going to be, they were kind of talking about this whole material litigation piece, and that's really what Cooney was focused on. He went on then, the judge then went on and made a distinction. He drew a distinction between the declaratory action and a pursuit of damages. So the declaratory action was the first filing. A pursuit of damages was the amended filing. And is that what made it a more material litigation? Again, we'll get into that here in a second as well. The judge seemed hung up, to me, from what I was seeing through these texts. He seemed really hung up on a couple areas with standing. Like there was a lot of back and forth with standing, and it gets in both to that material litigation, whether or not they had to take the vote because it was material. And Cooney focused on this fact that the first filing was a narrowly targeted declaratory action, and it was not material. And the judge as I said, he's going to have to determine whether or not that's material or not. That's going to be really the difference between whether or not they needed to have this vote, which everybody knows they didn't have for the first filing. Lastly, they argued that Florida law is very clear. FSU can sue and be sued in all courts. Words would need to be added to Florida law if sovereign immunity was to be bound only by state boundaries. We've talked about that in other episodes. And it's just FSU can sue and be sued, period. I think, to me, that one's pretty clear. I think ACC has a good case with that wording. King then came back up and continued on standing. The judge stated that you don't have authority to sue until there's an injury. So, we talked right before we came on, a lot of back and forth with the judge here. And, I think depending on how you read some of these tweets, it could be, well, the judge is picking a side with his questioning. And I don't think that's the case. The judge is just asking questions to better understand the sides and which, the facts that they're kind of trying to represent from each side. But I will just say before we I'm going to throw it to you and then we'll get into the motion to seal for ESPN. Again, the two main points here by FSU was the whole standing piece and that this is a material litigation. I mean, they were really pounding those two big items. And I think you could kind of tell that the judge was skeptical about some, especially the standing part. You could tell he was skeptical. Cooney tried to answer some of his questions, but it's going to be a judgment call on this judge whether or not he thinks a vote needed to be taken because of it being a material action. So what were your thoughts on that, Steve? And then we'll get more into the seal side of things.
Yeah, so first of all, just from following along today, I'm impressed with the judge. I like you mentioned, the Clemson case has also been assigned to his court. His court is specifically a business court, and there's a lot of speculation. I think it's anticipated that the Clemson case is going to be combined with this. Right. I think that's kind of there's concurrence on that, concurrent opinion from a lot of experts that think that's going to happen, which I think makes a lot of sense. And I'll say there's things that I really thought were going to be just a non-issue, easy to get through, that ended up being major hang-ups. The judge had a lot of pointed questions about those things. And then and then maybe there's other things that I thought were going to be more of a big deal, and he kind of dismissed them or didn't seem too concerned. And so one thing I'll say, a lot of people, because I was following along a few different people. One of the accounts that you follow, and I was following, there was another account, I think he's a Duke grad, and it's amazing how, kind of one side or the other, they really read into the questions from the judge or statements from the judge how they wanted to. If it kind of fit their narrative, they really, oh yeah, he's asking this. That's because this is important. Yeah. And whereas the other side kind of took some other things. So that's just, I would just caution people to read too much into the questions that the judge asks. And I don't think when he asks a question, I don't think he's expressing an opinion so much as he wants to hear from a particular side or both sides their, more about a certain issue. As far as the standing, I've said all along, I didn't think that the date of the vote was going to end up being such a big deal because they were able to remedy it. But obviously the judge is really taking that into account to find out, did they even have standing to file this case at all when they did, which I'm a little surprised at. So yeah, that's kind of my thoughts from the first half. Now I was working today. We both have day jobs. Yes. And so I was working, so I was trying to follow along over my lunch break, and I actually ended up following along with more of the second part of the case, which I know you're going to get to. Yep. And so I may have missed some things in the first half.
Well, I'll let you take most of the second. A couple things I want to talk about with the motion to seal. Before we get to that, I'll just say the Clemson case did get brought up multiple times, and this just was filed by the ACC earlier this week. So it's already on that radar, the judge's radar. Again, he was assigned to the same the case was assigned to him, so he's got both of them. I have heard the same rumorings that they potentially could get combined here, and you know, it makes sense. Obviously, if he's going to rule about something on this, and there's another case that's exactly the same type of situation, just another school, but still with the ACC, it makes sense that he would do both. I actually, you know, in terms of the questionings that you mentioned, I think there was a few times, and again, it depends on how they're tweeting this out, but it definitely seemed like the judge was, I don't want to say steering, because again, that leads you to a certain conclusion, but his line of questioning got the FSU attorney into another area, and then he asked, "Well, is that what you meant as part of your brief? Is that what you meant in your brief?" And Cooney, I guess, was kind of something like, "Yeah, that's what I meant, but maybe I didn't explain that good enough in the brief because they got to a different area as they were talking." Now, whether or not that's because of the questioning from the judge, and so the attorney had to kind of think on his feet and take a side road here, who knows? But that type of stuff happens when you have a lot of this question and answer.
Yeah, and I'll say, obviously, in a trial, in a court case, you don't want to see witnesses being led to a certain point by attorneys. However, I do think it's very appropriate, and I think he did a good job, this judge did a good job of, I'm going to steer these attorneys into where I want them to go to tell me more about their argument. There's a lot of broad arguments being made, a lot of allegations. I want to hear more about specific parts. What would happen? Okay, if I did this, what would happen? And I thought he did a great job with that. And as far as mentioning the Clemson case, I even saw some reports that as that Clemson case was mentioned, that they brought it up on the screen in the courtroom. So we'll see when we get the video. Hopefully we can see that. That's really interesting too. So
before we get to the motion to seal, there was no, he heard the case. He did not come out with any conclusion. He said he will take this under advisement. He's going to think about it for a little while. He's going to have a written order as soon as possible, but did say it would be certainly before April 9th, which is when the hearings begin down in Florida. So we're going to hear something before April 9th, but we really don't know how quickly he's going to turn this around. So let's get to the motion to seal, which also he did not come up with a conclusion here in this either. Everything is under advisement here. So Stone was the attorney that addressed the court for the motion to seal. And the judge, the part that asked, that really stuck out to me here was, well, first of all, two things. One, it was a lot longer than I thought it was going to be. I thought this was going to be pretty cut and dry, and I'm going to let you get into some of the details, but I was surprised how long this piece kind of went on for. But the judge asked why a motion to seal wasn't requested in Florida. It's only been requested in North Carolina. Kind of an obvious question to ask, and I'm going, that's a good question. Why the heck didn't they do anything in Florida? And according to what I got as the response from Stone, her response was that it would only bring more attention to this sensitive information if we were to move forward with it.
Doesn't make any sense.
What kind of answer is that? I would like to know why they don't have this motion to seal in Florida. I don't know. Her answer was a non-answer. It's just, we don't want to bring more attention to it. Don't worry. There's plenty of attention on you guys right now.
I'm just going to make a guess. Okay. I know you're going to throw it to me, but I'm just going to make a guess. They wanted to see if they could get it here before they go and fight, because they know they have a little bit of time.
Sure.
We'll see.
But why can't you say that? If that's the case, why wouldn't you just say, well, this could maybe set precedent or set, I don't know. I just don't understand why she would answer that way. But go ahead, Steve. What did you get out of the motion to seal?
Yeah, well, like you said, much longer than I anticipated. Yeah. I really thought this was going to be a pretty easy matter. I didn't know, first of all, how much Florida State was going to push to keep these documents open and have them be public evidence in the case. I really thought there would be kind of an agreement that they would make concessions. Okay, certain things that are trade secrets or whatever can be kept sealed or have a protection order for them so they're not made public. But Florida State was really pushing to have these kept open.
Yes.
And the judge seemed really open to it, which again I was surprised. He had pointed questions from both sides of what will happen if they're what are, and there was a lot of questions going back and forth about would the ACC be harmed?
Right.
Would ESPN be harmed? I know there were ESPN attorneys in the courtroom. I'm not sure if they got a chance to speak at all.
They had time, and I can't remember if Stone was an ACC or an ESPN. I believe she was an ESPN.
Okay,
attorney,
all right.
I believe.
Yeah, so there was a big question there as far as would the ACC and ESPN be harmed if these documents were public, and he didn't just accept it on face value that they would. He had a lot of questions there, and so to me, I really think again, I was surprised, and I think I'm just kind of theorizing here, but Florida State, with as hard as they're fighting to keep these documents open and to the public, I'm just wondering, what is their strategy behind that? Are they do they want to have just, is there some things in there that they think, will create public outrage if these are, the public sees, oh wow, this is ridiculous, this contract. Do they want to make these available to the other schools and so that they can use them in lawsuits because they're trying to bust through the door and let all the inmates out kind of thing.
Right.
So I was really surprised, and again, some great questions by the judge. Back and forth. There was one, again, I try not to read too much into his questions, but there was one comment that he made when one of the attorneys was speaking, about the about Florida law, about he made a comment and said something to the effect of, yes, that's true, but they must follow the laws in the states of the members.
Right. Yes.
Like, he made a point of saying that and clarifying that. So again, I try not to read too much into the questions, but the way he pointedly said following the laws in the states of all the members was huge. So that's pretty much all I have on that. It was a lot longer than I anticipated.
Yes.
I'm looking forward to watching the video, and we're going to do more of a deep dive. I know JY said at the beginning, normally we kind of wait. Both of us were following along. This was just so interesting today. We wanted to get on and kind of get the conversation going, but we are going to take a deeper dive into this. Hopefully, maybe we can get some transcripts. Maybe we can get the video. But it was just so fascinating today. Things that I didn't think were going to be that important, the judge was really pounding on. So it's kind of a new ball game at this point.
Well, and maybe the answer for the motion to steal in Florida is they know they're not going to get it. I think every time we have a video on FSU, there's always at least one commenter about the sunshine laws in Florida. We're fully aware about the sunshine laws in Florida and every state, but we know that they're pretty broad in terms of what they should allow for in Florida. We understand that, and maybe that's part of it. Like their eggs are very much in this North Carolina basket. And, they're hoping for a stay. They've already objected. We just, earlier today, our episode came out on the objections to all of this. And one of the objections to this information is that it wasn't protected. So maybe the real answer is it's not worth our time.
And it makes a lot of sense because I've said this from the beginning. I really think North Carolina or ACC, they had a smart strategy to try and file first. Legally smart strategy to get it in North Carolina. And I think they are kind of putting all those eggs in one basket, and they're banking on, hey, we want to get this case held here. These laws are, they pushed back on that and said that they weren't trying to find a favorable venue, that they believe that that's the correct venue. Great. You're always going to say that, but it's obvious. Everyone understands that North Carolina is a more favorable venue for them. And so, if they're putting all their eggs in this basket, if they don't get what they're looking for here, I think they are pretty terrified of this going back to the state of Florida. Now, the one interesting thing that I think it can still happen, we've speculated about this, is where we have concurrent cases going where both courts in the states of Florida and North Carolina, they've determined that it should be going on there, that case should be heard and move forward, and they both move forward at the same time. But at this point, the ACC is putting all their eggs in the North Carolina basket.
Well, the last thing I'm just going to say is that whole rush to the courthouse type of thing that FSU, that didn't seem to play, from what I was reading, with the judge very well. That just didn't seem like that was an issue for him. The vote and the materiality, the standing and the materiality were absolutely the two hot items here for this judge. The rush to the courthouse, I don't think plays for him at all. So with that, hey, we had to do a breaking episode on this. We will absolutely do a deep dive on this if we're able to actually listen to this. I think we will. I'm sure that won't be till maybe next week or even later, depending on when they get that posted. And we have time to sit down and enjoy 3.5 hours.
Yes, I'm excited.
Of a hearing.
I love it.
Yeah.
Sports court.
There you go. So, hey, with that, we thank you you guys for watching. We stay on all things FSU ACC and now Clemson ACC. Make sure you give this one a like. Make sure you subscribe if you like our content. And we'll see you next time on the Big Mountain.